Kevin Patrick Brady, Rochester, New York. Civil court corruption. My name is Kevin Patrick Brady from Rochester, New York. I am unemployed, and I have been unemployed for about 5 years because I ran into a runaway train that's called our judicial system. After 17 years of infinitely destructive experiences with our third branch of government, I am able to attest with absolute conviction that America's justice system is an insidious pay-for-protection racket. Simply for having once chosen to exercise my right to represent myself in court, I have lost the most productive years of my life. I have been driven into abject poverty. I have been punished repeatedly and, in fact, unanimously by the countless liars, cheats, thugs, and thieves who control our courtrooms, our liberty, and our lives. Since January 1995, I have been criminally prosecuted 6 times in local town courts, convicted by ill-informed juries of lay people, fined, incarcerated, and ordered to report to probation for years thereafter. As a matter of long-established law, every accusatory instrument failed to state a crime or offense cognizable in New York courts. Although I asserted these clear facial defects at every arraignment, the courts and prosecutors ignored them and proceeded to trial. So did the appellate courts, to which I took my pro se appeals. Despite having been found guilty, with one exception, there is no evidence in any trial record to support my convictions. Since I first petitioned to enforce my civil rights in 1995, every court and every prosecutor has taken action against me without cause and without personal and subject matter jurisdiction. Every court has ignored prima facie evidence of their lack of jurisdiction and refused to vacate, set aside, or declare their wrongful judgments and convictions void. In the years since, I have been forced to file more than 50 petitions, motions to purge unauthorized, jurisdictionally void blemishes from my record. Every affidavit deposed how they had been obtained by fraud, extrinsic fraud, and fraud on the courts. They enunciated years of judicial nonfeasance, failures of court officers to perform specific ministerial acts required by law, serial false arrests, malicious retaliatory prosecutions and incarcerations initiated by an unauthorized prosecutor acting under color of law on personal vendetta and with conflicts of interest. Are you listening? To this day, no court has adjudicated even a single issue I've raised in my complaints. The void judgments remain on my record, polluting my personal and professional credibility, my credit rating, and eventually bankrupted my business. Once upon a time, I believed that as a United States natural citizen, I had basic and forcible state and federal constitutional rights. Ha! For me, the cheat is essentially complete. Is being heard. My brother once noticed, my brother recently noticed something about me. He said, "Why are you talking so distinctly?" I said, "Colin, it's from years of trying to express what I know is right and just being discounted and ignored every time."
Every time? Oh, come on.
Every.
All right, Pat. How far back you want to go? What do you want to talk about? You just take it away, and I'll throw in questions when you pause.
Well, I have been all through the family court system. I know it well. I know that it's all just a stage, just a play. They all play their little roles. It's infuriating. It's destructive, but that's what we've got. And it is far, far, far out of control. Oh, looking at you. Okay, that's good. After 2.5 years of waiting and paying attorneys along the way to get a visitation order in place, 2 months after the order was finalized, an incident occurred. Family court administrators came in, busted up the visitation agreement like it never existed, changed all the terms around. The mother and I had a stipulation of how we were going to transport the child for visitation. So, like I say, the family court administrators, not the assigned judges now, just the administrators, on rumor, just acted to change my visitation contract. Now, I got a little mad about that because it cost so much money, and I kept saying, what about due process of law? I repeatedly called the courts, and acting as my own attorney now, wanted to know when my hearing to exonerate myself would be held and when I would have my kid back for visitation. I got a letter in the mail shortly thereafter threatening me with criminal prosecution for attempting to represent myself in family court, which I thought was a little strange. I called the district attorney's office and they told me, well, no, that couldn't happen. Well, I was wondering why the judge who threatened me didn't know that. So I filed a Title 42, Section 1983 action in the Western New York District, United States Court. Dismissed immediately, without appearances. But the judge did say that he didn't see any reason why my constitutional rights could not be adjudicated in the state courts. So I thought, well, I must have gone to the wrong court. So I filed it in Supreme Court. During the first appearance, that lasted no more than 15 minutes. We all said our piece. As the plaintiff, I went first. All of the lawyers then representing the judges who I have sued, who were all in this conspiracy, the lawyers spoke next, defended their clients. When I got the decision of the judge in the mail, lo and behold, I was enjoined from filing any action ever again in any court, state or federal. I was also ordered to pay money to the judges. It was worded reimburse the parties for having to defend this action. Well, those parties were judges, but the ordering judge didn't care, or he didn't know that they were judges. He just blindly signed an order that was proposed and submitted to him, and left me with the consequences. See?
Let me stop you. Let's go back to the order, the death penalty on filing. This was done in Superior Court?
In New York, it's called Supreme Court.
Supreme Court.
Yes.
And what do you recall that the order said?
It said that plaintiff, me, is hereby enjoined from filing any action in any court, state or federal, without the permission of the presiding judge. It also said that I am to reimburse the opposing parties for having to defend this action. Now, the opposing parties were judges. The guy who was charged with the task of drafting the order for the judge's signature, he knew they were judges, and he knew that there wasn't any expenses because his office indemnifies them. Nevertheless, he put it in the order, and the judge signed the order, which libeled me for about $20,000 back in 1995. That order still exists today. I have never, ever been able to get it off my record. The reason is I filed a notice of appeal and all that, but the same guy, Carlos Rodriguez, later filed an affidavit in the appellate court saying, hey, Brady never filed a notice of appeal. Well, yes, I did. I filed a notice of appeal, but I filed it in the wrong court, you see? And I filed an affidavit back in the appellate court saying that I did file a notice of appeal, just in the wrong court. It didn't matter. They still dismissed the appeal. So I never heard anything further about that order. And the reason is that all of the parties that were in this action, lawyers, state attorney generals, they all knew this was a fraud, that the order was not enforceable anyway. So it just died. It lay dormant for the next 7 years. No one ever tried to enforce that judgment.
Did they try to enforce the order that was blocking you? Did you file action?
No.
So you were able to file without seeking?
I didn't have any reason in the interim to file.
Okay, so you didn't test it.
Right. Along comes another petition from Mom, who wants to, let me back up. Child turns 13 years old. Big milestone. Adolescence. I never had any difficulty with my kid whatsoever. Had an excellent relationship with her until she turned 13. All of a sudden, she packs up and leaves Dad's house. Never saw her again. This is 1999. So I filed another action for custody because I know this is all Mom's doing. Mom is deliberately alienating the kid, making false accusations, and my daughter's half-sister was backing it all up, demonizing me. So there was a second custody action. In response to that custody action, Mom filed to increase child support. See, not only does she not want to go visitation anymore, she wants more money. Well, she didn't get it. She didn't prove she needed more money. But nevertheless, I was still found in civil contempt for not paying basic child support. I was found in contempt for not reimbursing Mom for incidental medical expenses that Mom never actually even sent me bills for. The further infuriating thing is my job at the time would have covered those expenses. See? But she never sent me the bills. And I tried to tell the judge that, but to no avail. I was found guilty and ordered to pay Mom's attorney. Now, I knew that the order to pay the attorney was not enforceable. It's not legal. It has to be on order of the assigned judge, not the support magistrate is what they call them, and the assigned judge never approved the finding of contempt. And not only did I not want to pay Mom's attorney, I didn't want the judgment lien on my record. The attorney went down knowing that it was not enforceable. He filed it in the county clerk's office anyway. And that immediately set off my credit rating, started to creep up. I knew that it was a blight on my professional record. So I filed an action in Supreme Court. You want me to keep going here? I filed an action in Supreme Court because family court wouldn't abide by the due process. I wanted to get that attorney's award off my record, so I filed writ of mandamus. I hope you guys are ready for this. Because I need permission, I had to notify the administrative judge, who is Tom Van Strydunk, Monroe County, Rochester, New York. Tom Van Strydunk. I had to ask his permission. And he gave me permission, sent me a notice. You are to appear in court on November 13th, 2002. So I did. Unfortunately, within 2 minutes of that court appearance, I was essentially ambushed by Van Strydunk, who says I was here to, I was making an appearance for the writ of mandamus, but then he went into these tirade of accusations against me based on hearsay. Frankly, I had no idea where they came from, but the allegation was essentially that I never paid these judges back 7 years before, and he was going to put me on trial, require me to testify whether I paid these people or not. I was dumbfounded. He was there with me that day. Speechless. I could not imagine how you can lure me into court on one pretense and then charge me with a crime, quasi-criminal, but that's what he did, and would not let me object, kept ordering me to return to court for the next 14 months. I had to go through a whole trial, which at some point I absolutely knew this is just a fraud as overt as could be. Nevertheless, I had no choice. At the end of the trial, as predicted, I was found guilty and ordered incarcerated for 60 days. So I did my jail time. It brought my business straight down. Not being around for 2 months, I ran a financial services business, sole proprietor. So, make a long story short, it brought me down. Having studied all of the elements of the phony prosecution and, the merits, I discovered that these whole proceedings were as lawless as they could possibly be. It's almost like Van Stuyden sat down and deliberately put all of these defects in some sort of game, perhaps. It certainly was a malicious prosecution, and it was retaliation for having the audacity to file an action pro se because the courts upstairs were violating my due process. To this day, I don't understand it, but it does anger them, when a assertive pro se person comes along. They're going to crush him.
Let me get a soundbite from you that says, I filed a pro se lawsuit seeking my civil rights and was rewarded with 60 days in jail and a criminal record.
Sure. I filed an action pro se to enforce my civil rights, and my reward was to be prosecuted, punished, sanctioned, fined, and incarcerated for 60 days, and it cost me my business. Not only that, as soon as I got out of jail, I was charged again for contempt for failing to report to jail precisely on time. Now, as I said earlier, I have studied these proceedings inside out and backwards, and I know that there's absolutely no jurisdiction. They didn't have personal jurisdiction, called me into court on an entirely different matter, and then accused me of ancient crimes, long past statute of limitations, made me defend it. I can't read that.
Statute of limitations. citations on that, of course.
Yeah, okay, I just said that. So those are the quasi-criminal prosecutions. To this day, as I've said, 50 petitions. And because I am enjoined, all the other courts seem to say, well, you know, he doesn't have any power to do anything. And they just dismiss every single one of them. And it's also funny that since I began suing judges, I have also been charged in local town courts, you know, for little contempts here and there. But they all relate back to family court stuff. I would like to know, Congressman, whoever, where does a local town criminal court get the authority to charge, convict, and prosecute me for another court's order? Now, we're not talking about an order of protection. I understand legislation has made them special. We're just talking about alleged civil infractions of a family court order that I have to answer to in criminal court. Well, I've had to do that 6 or 7 times. Every one of the proceedings are facially void. You can just look at the accusatory instrument and know that it doesn't state a crime. But I'm still guilty, and I'm still carrying the consequences. I would like to get back to work someday, but I don't want to work at Mickey D's. Not that there's anything wrong with Mickey D's, but I had a profession, and I spent many years developing it, and they took it away as if it was. I wrote this once to a judge. I said, "You gave my appeal more thought and consideration than your morning bowel movement." Yes, I put that in a letter.
Gave more or gave less?
The judge, you gave my appeal less consideration than you did your morning bowel movement. She wrote back immediately recusing herself of any future dealings.
Because you were right. I guess you figured she needed to bail. She was probably on the pot while she wrote that order.
You know, I to this day, I can't imagine how someone would be so callous with a criminal conviction, someone else's criminal conviction. It's almost like Judge Patricia Marks, Monroe County, New York, decided, well, we're going to fix this pro se guy. And that's what she did. But she certainly, that decision put me in almost an obsessive state of mind that has lasted all these years. I want these things off my record, and it's because I want them off my record, and I'm so emphatic about it, is the exact reason why they won't vacate the judgments. I'm absolutely convinced of that. And I'm rambling.
Well, you want them off your record. They want to stick you any way they can. They're not going to give you any chance, but you're going to continue to fight. Is that it?
Well, I don't have to fight much longer, even though it has taken me 10 years to get all of the ducks in a row. See? Now, and this is only recently filed in the last week, is a writ of error, demanding because of prima facie evidence that these are not crimes and that there was no jurisdiction, demanding that whoever the lucky judge is who gets assigned to this petition knows that it's not a discretionary thing. This must happen. And if he or she tries to squirrel out again from this thing, we're all going back to federal court. The only problem with that is federal court is just as corrupt as state courts, if not more. So I'm in a rock and a hard place here. I know I have been, as Randy likes to put it, made love to anally without any Vaseline, without any lubrication whatsoever. And they all know it. They just have the power, and I don't, and they want to get that across to me. I don't know how so many people can fall into this same occupation, this same culture. I don't think, it's like they were all raised by wolves. They have no sense of decency or accountability whatsoever. I would like to see the third branch of government wiped off the face of the earth. I think we would get along just as well without them. Without civil courts, not talking about criminal courts. Unfortunately, we would be left to resolve our disputes, grievances by flip of a coin, but that's what it is now. And just the cost of eliminating America's third civil branch would be greatly satisfying to me. What have I left out? What have I left out?
What needs to change?
The culture of judges, lawyers, is corrupted beyond articulation, beyond repair. I haven't got a clue how to go in and change that cesspool. But the result is we have all these attorneys coming out of colleges, entering the workforce, and sooner or later they learn that it's not about law. It's about what the judge decides. If you ask any lawyer or express an outrage that, hey, wait a minute, the judge can't do that. They can't discuss it. They can't speak about it on their own. They are all just driven like the movie The Time Machine, where all the monsters were drawing in the Morlocks were drawing in the Morlocks and the sheep, for lack, can't remember the word. That's what the judiciary is. It is disgusting. Have I made my point? Take it from me. I've been there. I have lost everything I ever worked for. And I have not done anything. I have never committed a crime. I have never filed any action in any court that legally or constructively rose to the level of frivolous, vexatious, and or completely without merit, and yet I have been punished on every occasion for attempting to exercise my rights. End of story.
Should pro se parties be a protected class?
Yes, as a matter of fact, they should.
Should you say that as a full sentence?
Okay. Pro se litigants must be protected. They must be recognized as an abused minority and expressly given their rights, no uncertain terms. I don't know why the courts love to hate pro se people, but they do. And they punish them indirectly, and many times, like me, we don't even learn that this is happening until it's too late. We're in a hole that we'll never get out of.
Are you aware that a third of the people on court now represent themselves, and that doesn't count those in criminal court who get assigned somebody to represent them, which is almost as bad or worse? A third.
I've heard those numbers, and I must say that apparently the courts are treating pro se litigants who sue each other different than pro se litigants who sue corrupt government. That's the part also that I've never seemed to get across to these judges who enjoined me from filing action. I'm suing government. I'm not harassing other litigants with vexatious, expensive litigation. Every lawsuit I ever filed has been because of a corrupt judge.
What, to you, what does the term petition the government for redress of grievances mean?
Well, what does the petition for redress of grievances mean? I think it means exactly what it says, that we have the right to be heard. We have the right to defend ourselves against arbitrary government, and they just scoff at it. They treat it like trash.
What would you say to people who, probably 99% of the people don't realize what the situation is with the courts? What would you tell them about their constitutional rights?
What I would say about the American people's constitutional rights is that don't kid yourself. You do not have any constitutional rights. Law in this society is only as good as your ability to enforce that law. And if you come up against a judge, and you will more than likely come up against that judge who does not want to enforce your rights, you're not going to get it enforced. I can't say it strong enough. It's a myth. It's a fantasy. Constitutional rights do not exist. Sounds good, but in action, it's not there.
Why do you think it is that, do you think judges ignore the facts in the law, and if so, why?
in my experiences, judges predominantly ignore the facts and the law. Why they do it, I have always had much difficulty understanding why any human being would just deliberately deny another human being their right of birth. But they do. I don't know why they do it, except to say that it must be a spiff of their job. And they actually play sport with it. If they can't get higher salaries, they're going to abuse litigants. That must be the reason. I can't think of any other reason.
Have you requested jury trials?
Yes.
Have you ever had a jury trial?
Yes. The problem with pro se requesting jury trials and is that district attorneys have infinitely more credibility with a jury of lay people that is almost impossible right from the bat. If the district attorney says I did something and that it's a crime, they say, yeah, well, it must be. District attorney wouldn't lie to me, would he? Well, I've seen them lie to juries 3 times. Look juries right in the eye and tell them that I violated an order of protection when it was, in fact, a family court order of visitation that I was charged with. If it wasn't a order of visitation, if it was an order of visitation, it cannot be prosecuted in criminal courts. But we were in criminal courts, so it had to be turned into an order of protection. It's bizarre.
If I may interject, I seem to recall that you had a jury trial at one time that found in your favor, and after all was done, the judge threw it out and made his own decision anyway.
Well, that is true. Earlier I said that I have been convicted by a jury of lay people, with one exception. I did actually get a jury to see that the person who was charging me with having violated an order of protection was not the protected subject. See? It was the father of Mom who said, well, we have an order of protection against Mr. Brady. Well, no, we didn't. Mom had the order of protection. So the jury did see that, and they acquitted me of that.
And then the judge?
Yeah.
What did what?
This is back to Patricia Marks again, the one who gave more thought to her bowel movement. She changed all the rhetoric of the appeal decision, which included all of the allegations. That I went to the house early, that I was angry, and I was pounding on the doorbells and all this. It's exactly what I was acquitted of. See? But it's there in the recitation of the appeal. So I don't know why they do these things.
Sure.
I thought you would know why they do these things.
I don't know why they do it, but I know they do it. The judge falsified.
Absolutely.
All right, say that as her name and say it as a soundbite.
Judge Patricia Marks, Monroe County, lied in her appeal recitation about the facts and the law in order to keep me convicted. Now, without the lies, I could not have been, the conviction could not have been sustained. Not legally, anyway. So the woman just wanted me convicted, and that's that. Speaking of lies, Judge Patricia Marks is not the only judge that I can show that they lie. This Tom Van Stridunk I was talking about earlier, I've got an 8-page decision from him. Every sentence is a lie. And, you know, he must know this. He must know that it's lies. But they also must know that I'm never, ever going to be able to do anything about it because it can all be tossed into that judicial discretion thing. See? Whatever a judge wants to observe in a courtroom, it's his right to observe and to talk about it. I don't think society can work very well if these judges can lie. But they do. Often. It's not the exception to the rule. It is the rule. In my experience, it is the rule, not the exception. And that is to teach pro se parties that if they come to court without an attorney, they have a fool for a client. I am so disgusted with that expression, I could just scream. The other expression that never ceases to infuriate me is that we are allowing foxes to guard the hen house. Oh, God, if I heard that ever again.
If I recall correctly, as a matter of law, I recall that you sued 4 judges civilly and then criminally in federal court.
Yes.
For falsely putting false information on a record.
Yes.
Which is a felony on the part of the judges.
Yes, I have filed criminal charges against more than one judge. And there's nothing in New York law that says I can't do that. The district attorney, however, perpetuates this myth that he or she is the only officer that can actually proceed with a criminal charge. It's not true. Everyone, if you know a crime occurred and you can prove it, you can file it and you can prosecute it if you are confident enough with your ability to present it to a jury. That's the law. Good luck trying to enforce it.
When I checked into the hotel downstairs, I handed the young lady a business card, told her we're filming a movie up here, and she asked what the movie was about, and I told her, and I said, have you ever been a victim of government or judicial corruption? And she said no.
Oh.
What advice would you have for her?
Oh, it's only a matter of time. They're running out of victims. I don't have anything left to give or to have taken from me. They have to go find new sources of new victims. I have to constantly keep recruiting new victims.
Well, similar to that, when we left the hotel room in Augusta, Maine, a bunch of people were going down to the cars at the same time, the last of the people who were interviewed. And a woman, fairly young woman, got on the elevator, and I apologized for all the equipment and stuff we had. And she said, "No problem." I said, "We're filming a movie." She said, "Oh, what's it about?" So, it's just a common question. I told her. I said, "Are you a victim?" She said, "Aren't we all?"
Yeah. See, those are the kind of answers that I encounter too. Most people know that there's something wrong with this system. I like to say, whoever thought, whoever conceived, whoever proposed, most of all, whoever agreed that this society, this American experiment, could operate perpetually on the honor system. The third branch of government has no one to answer to but themselves. And these foxes certainly allow each other good eating. We have to get in there and discipline them. We have to let them know we're coming. We have to publicly prosecute and punish quite a few of them to get the idea across that times are changing, that we're not going to allow our fellow people to be abused by these cads. That's a euphemistic term. Scoundrels. Scumbags. Excellent word. We started to call them Baxters for short.
I've been Baxtered.
Yeah.
You were Baxtered before me.
I think when I became aware of you, I was pretty much saying, hey, this guy has had, happened to him. I've been there. I know what he's talking about. And I also don't like to admit that my experience goes back 17 years. It's the only thing that's been on my mind for well over a decade. If you can even fathom that, think about having only one thing on your mind 24 hours a day, 7 days a week. That's the way I have lived since I was lured into Tom Van Strydunk's courtroom and ambushed and jailed.
Okay, we're rolling again.
Listen to me while I tell you of the bastard that blighted me life. La la la. List. Go ahead.
As I was driving today, I said, it's time to break your song you did about me out again and get it and put it out.
Oh, yeah?
I need to do that.
Yeah, well, I brought the judicial gown, so I was going to come in, but geez, you put that thing on and your body temperature goes up 25 degrees.
We're proposing to every state legislature various things that would improve the situation. First one is the easy one. Record every court proceeding of any type and allow each party to record independently if they choose.
Absolutely, a must.
How can they say no to that?
Well, they can if they have to also be conscious of the stenographer's lobby, stenographer's right to earn a living, and all that stuff. I would like, and you would like, if you are put in a defensive mode, to be able to defend yourself. And I have volumes and volumes of transcripts that at the time I ordered them because I thought I could use them someday to defend myself. I have never had the opportunity to submit them, but they were tampered with. Over and over again, they were tampered with.
Let me get you to say that as a soundbite. From my experience, repeatedly the court transcripts have been tampered.
From my experience, the question of tampering with transcripts is not a question. It's a reality. It goes on all the time. And I only wish I could sit someone in authority down and just take a look at my evidence to prove that. My problem is that I have to show my pleadings to a court before I can get approval. And I never get approval because of how damaging my presentation, my case is. It's infested with fraud, tampering with transcripts, fraud and abuse. It's endless. It's obsessive with me to get this out. Now, I told you that I just filed this writ of mandamus. I really hope that the players are going to say, time has come. You know, this guy, Brady, he's got us blocked. You know, there's no question whatsoever about his evidence. So we're just going to say, okay, all of these proceedings are vacated, you're free to go, but we're not going to discuss any of the, things. We're just going to, let it go. Because the criminals who put me here belong in jail. Those who put me in this position belong prosecuted and jailed. That is, unless you would like to go through it sometime too, and then we can just allow them stay where they are. They'll get around to you.
Would it be a help if whenever a person pays a fee for a jury trial, that they're granted that and the judge is blocked from being able to dismiss or summary judgment him out?
I don't know, because I don't trust jury trials either.
Okay.
I don't trust judges. As a matter of fact, I got a letter once telling me that I was picked for jury trial. Oh my God. The court clerk, when he was through talking to me, he knew that I was not a proper candidate for jury. Without question, he just, excuse me, you're excused.
I was called to one, and it's the first time I've ever actually made it into the room, even though I've reported to jury duty for many years. And it was a DUI, and I regaled them with all kinds of humorous stories. And once we went back into the jury room, well, the attorneys were going to decide who to strike and whatever else. Everybody said, "Oh, we want you to be the foreman." I said, "Trust me, there's not a chance in hell that they will put me on that jury." And of course they didn't.
Because at that time you had already had some of your struggles.
No, I don't think I really had, or wasn't that bad. But I just.
So you were still wide-eyed and.
Well, no. I told them, I said, I don't trust any policeman, and they said, "Do you believe a policeman says is the truth?" I said, "Absolutely not. Why don't you?" And I said, Officer Vincent Petrocelli. And they all started laughing. They said, "What's the deal with Officer Vincent?" The judge just was hooting. So, "What's the deal with Officer Vincent Petrocelli?" I said, my wife and I were driving on a 4-lane road in the right-hand lane during rush hour with all kinds of SUVs and pickup trucks. And we were driving in a white Porsche convertible.
Whoa.
and in the opposite direction comes a police car. And he does a U-turn and comes up behind us and pulls us over and says that we were speeding and he caught us on radar. Now, it's impossible to catch somebody on radar coming from the opposite direction in this traffic. People were passing us, we weren't speeding. And you just can't do it. And then he writes the ticket out, and it claims we were in a construction zone. We were nowhere near one. And he claimed that he had followed us for like several miles. And he just turned around, he just completely lied. So I said, I fought it. I went to court. And he got up there and just lied his ass off about everything. I said, so, no, I don't believe that policemen tell the truth. I don't trust policemen. Mm-hmm. And then they said, well, have you had any experience with driving while intoxicated? I said, sure. I was in college. I said, I think, darn near everybody did. And I said, once I had a bunch of employees that took me out, and I didn't know the game quarters. I missed that. That was the next generation after me. You ever played the game quarters?
No, I don't know what that game is.
You bounce a quarter into a cup, and if you get it, you get to point to somebody else with your elbow, and they have to chug their drink. So little did I know, they had it all set up. Every time they got it in the cup, they pointed at me. And so I was commode hugging drunk. And I'm telling this to the whole courtroom. And I said, I got in my Jeep and I pointed in the direction of my house, which was only about 1.5 miles away. I saw the median, but there wasn't any, the reflexes were not there. I couldn't do anything about it. And then I see the flashing lights in the rearview mirror. I'm going, oh my God, I am going to go to jail. I'm going to get DUI. I am stuck. And I said, these guys came up with these flashlights that had heads on them that were bigger than a medicine ball, And they shined them in, and they said, Mr. Windsor, how you doing? And I'm going, I was drunk, but I was alert enough to realize, well, they haven't asked me for anything. How the hell did they know who I am? And of course, they got the big lights. I can't see anything. Turned out they both worked for me. And we had donated building supplies for them to build another jail. So they let me go.
Oh,
They said, can you get home okay? I said, sure. I just have to go down there and turn left and then turn right into my driveway. I'm pretty sure I can do that. They followed me the whole way, and I made it home.
I got 2 more things, and actually they're too good to leave out.
All right, great.
Because because of my bankruptcy, I've been unable to pay my mortgage for 4 years. The only way I could get into court with my allegations about the fraud, which resulted in this judgment, this phony judgment, that was a lien on my property, was to allow myself to be foreclosed.
Because you could go down and file an action because you weren't allowed.
That's right. In defense, that's exactly what I did. And I listed all of the beautiful little statutory schemes that are woven into New York law that allowed me to do that. I was so proud that I had actually, beat these guys. They wouldn't let me into court if I'm just complaining about the void judgment. But if I am sued, I can initiate a third-party action. So what happened was I was sued by Wells Fargo, who now are notorious fraudsters. They could never come up with the mortgage document, proof that they were the party. So I filed all these motions. Well, sorry, Judge, you don't have any jurisdiction if they can't prove they're the plaintiff or if they can't prove standing. He summarily dismissed the action in Wells Fargo's favor. And he wrote on the summary judgment that I never showed up. Yeah, he filled in the blank where it says who were the defending parties. He wrote, no one heard in opposition. Now, what that means, he's trying to tell, anyone else who ever reads this is it's a default. I didn't show up. Well, that's not what happened. Wells Fargo has never tried to enforce that judgment since. So I haven't had to give away my house, but I never forget that. We've got a judge sitting on New York Supreme Court, John J. Ark, who knew that he was giving away my property without any proof whatsoever. He just gave it away, and when he did, he grinned at me from the bench. So help me God, he grinned at me. So I have been immobilized in this piece of real estate now for 4, 5 years. I can't pay for it. They put me out of work. I can't sell it because I have these judgments on my property. Somebody wants to buy it, I have to come up with 26 or 30 grand,
The town and county has not moved with regard to that.
All right, well, I'm going to get to that. So I am truly in a rock and a hard place here. So I named the Village of East Rochester as a defendant in this suit I filed in the New York Court of Claims, saying I can't pay my property taxes either. See, I got no income, and they're squeezing me, won't let me into court. So that is still up in the air, still unresolved. But the judge of the East Rochester Court allowed a prosecution to go through. I was the defendant again. I was charged by my former stepdaughter, who is now all grown up, carries grudges against me. Not for anything that I ever did. It's because she wasn't loved the way biological children are, It's an old story, and I'm sorry to admit it. It happened. I wasn't ever abusive to her in any way, but she didn't always get the love that she wanted. So now she's got a grudge. She charged me with, because I sent her a book on parental alienation. I want her and her sister, my biological daughter, to understand what parental alienation is. Now, to me, that was very definitively a legitimate reason for sending her that book. The statute, harassment in New York, says that that's one of the elements of the crime, that there has to be no legitimate purpose. They charged me anyway, and when I objected to jurisdiction, I very specifically said, Judge, this element of the crime, no legitimate person or no legitimate reason has to be in the accusatory instrument. If it's not there, you don't have jurisdiction. There's no crime. He didn't care. He allowed the prosecution. And you see, something like that can't be proven at trial because the book is there. Is that a legitimate purpose or not? Didn't matter to him. The appellate court judge upheld my conviction.
All you're trying to do is educate your daughters.
What Bell says to me is no good deed ever goes unpunished, So I'm going to get the last laugh here. Judge Scott Odorizzi East Rochester, New York, is now running for Supreme Court. He wants to be a Supreme Court judge, and yet he doesn't even know the basics of criminal law. So that an accusatory instrument has to state, has to allege every element of the crime. And if it doesn't, the trial court does not have jurisdiction. This man can be sued personally, and he doesn't know it. So every time I see one of his trucks driving around with, vote for Scott, it's got competent, trustworthy on his advertising. I just want to puke. Boy, oh boy. I'm exhausted.
All right.
This is just emotionally draining.
Let me ask you one last thing. What are your hopes for the movie, if any?
I hope that everyone sees Lawless America the Movie. I don't think, I can't say everyone, but there are far too many people who have no idea whatsoever how foul and insurmountably foul, is that the right word? Insurmountably? Pathetically foul. Foul to the millionth degree. That kind of foul. They're foul. And we've got to get them cleaned up, because you'll be there someday. Sure as I'm sitting here right now, you'll be there too. Boy, I wish I'd said it better than that.
Try it again. You didn't say who they were, so.
I didn't? Okay, what do I hope for the movie? What do I hope for Lawless America, the movie? I hope that everyone, and your brothers and sisters and children, grandparents, all go to see this movie together and then talk about it later. Because this scourge in our courtrooms is the greatest consumer fraud in the world. Dangerous consumer fraud. Our courts are occupied by liars, cheats, thugs, and thieves with absolutely no accountability whatsoever. That's got to stop. You are the people that have to make it stop now. And before I die, please.
I had a man earlier today who said he thinks it's domestic terrorism.
Well, it is certainly terrorism, yes. It is certainly terrorism. I don't want to start a whole nother segment here, but I have also been charged criminally for being a courthouse terrorist. Yes, I was. And it's just ironic that I'm retaliating against courthouse terrorism. What they're doing to me, they were able to turn it all right around and get me into a criminal court, put me in jail for protesting what some court clerk was trying to do to me. Block me from getting my case into court. It's that simple.
Yes, I'm lucky I don't live in Rochester or Henrietta or wherever.
You know what, though? It's everywhere. It is absolutely everywhere. It's not a local thing. This is a scourge that has been going on for an awfully long time, and it is pervasive in every court. I looked away when I said it.
Let's wrap.
Yeah, okay.
Great job.